How do you get rid of a tenant? A tenant may not be paying you money. A tenant may be squatting on your property even though the lease has expired. As an NRI who's living halfway across the world, how do you throw a tenant out of your property? Hi everyone, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and general legal information, make sure you hit the subscribe button below. So in a case where the tenant is not paying you rent or is squatting over your property even after the lease has expired, in that case, what you would have to do is that you would have to file a case against the tenant for eviction from your property and also for arrears of rent. So you would go to the court and you would say, please evict this person and also please make him pay the balance arrears of rent that he has been withholding from me. But before you do that, the first thing to do is that you need to issue a legal notice to the tenant. Don't underestimate the power of a legal notice. A lot of times, the tenant may just say, I don't want to get into this hassle. Let me just pay at least, or part pay, or at least get into some kind of a settlement or some negotiation. And that will open some channel between you and the tenant. So before you rush to court, make sure that you issue a legal notice first, asking him to get out of the property and to pay X or Y amount of money that is already due to you with interest. Now in the event he does not come forward to pay, or if he issues a reply notice saying I have a right to stay here and whatnot, then you would go to court and you would file that case for eviction and for recovery of balance rents. Now even in court, it makes a world of a difference whether your lease deed under which your tenant was staying was actually registered or unregistered. And you can also say if there's an oral lease, then that also falls in the category of an unregistered lease deed. If it is an unregistered lease deed, that document unfortunately will not be admissible in evidence. So no clause in the lease deed can be looked into for the purpose of to decide whether to throw out the tenant or not. I've seen so many cases where tenants come and show me these fancy lease deeds that are which run into hundreds of pages, and they say according to clause number so and so the tenant has breached this and I want to throw the tenant out. And it turns out that the lease deed is not registered to begin with. So nobody really cares what is written in the lease deed as long as the lease deed is not registered. So if you have a tenant, obviously the first thing to do is to register the lease deed. If the lease deed is not registered, then none of the terms in the lease deed can be looked into. On the other hand, if it is registered, then it is just a question of interpretation of the contract. So for example, the tenant has not paid for 2 months continuously, then the registered lease deed may say, look, if the tenant has not paid for 2 months, then he gets 1 week to pay. And if he doesn't pay for 1 more week, I have the right to kick him out. You go to court, you show that clause and your job is done. So that is as far as as a registered lease deed is concerned. Now what happens if your lease deed is not registered, which I think is the majority of cases where they are not registered. In that case also you have a pretty good case, because under section 106 of the Transfer of Property Act, you can give 15 days notice and ask him to get out. And this is a very common thing that people do. So even if you have an unregistered lease deed, you can still try to kick out the tenant. The problem actually is that these cases take a long time to be decided. So it's not like you file your case today, you will be able to throw the tenant out tomorrow. It will take some time. But in the meanwhile, what you can do, and I think this is important, because ultimately, if you get something 5 years later, 10 years later, that's good. But but what do I get today? What do I get, a week from today? That's what you're looking at. So let's say that there's a tenant who is squatting over your property and he's not paying you rent. So you can file an application while the case is pending. So you have the main case timeline, and while the case is pending, you file an application saying, let the tenant pay rent for the undisputed amount of rents. So what does that mean? So let's take, for example, that the rent is say 10 rupees, right? Let's say the tenant is paying you 5 rupees through the through white means, I guess, as they call it in India. So he's paying you 5 rupees through a bank transfer, 5 rupees through cash, right? So what you will tell the court, and let's say that the tenant is just not paying you, he's just stopped paying you at all, and he's still at your in your property. So I guess he's paying you the white amount and not the black amount. He's not paying you cash. He's only paying you white amount, which he used to do. Now he even stopped doing that. So you go to court and you say, look, 5 rupees is the rent. He's been paying me 5 rupees for so many years. He stopped. This is an undisputed rent. This even he does not dispute, because he's admittedly a tenant and he has to pay some money for staying in my property. So let him pay the 5 rupees that even he does not dispute. Now, as far as cash is concerned, now you may take monthly receipts whenever you receive cash from him. Now you may have income tax problems, but that's a separate issue altogether. But at least as far as the civil suit is concerned, even here you can come and press into service and say that, look, I have these cash receipts. He was paying me all these years, then he stopped paying me. So please compel him to pay me, or you strike off his defense. So that's what happens. So the tenant will be compelled to pay you that money. In the event he does not pay you that money and still squatting in your property, the consequence will be that his defense will be struck off, which means he can only fight your case, but he cannot introduce his own pleas in the case, which substantially weakens his case. So if the tenant is squatting over your property but not paying you any rent, or is paying you extremely low rent, then please consider filing an application for deposit of undisputed arrears of rent. Also, at the time of entering into the lease deed, it is advisable that you take some checks from the tenant, in the off chance he doesn't pay rent. Then in that case, if he has given you these checks, you can go deposit them and give a notice before you deposit them to the tenant. And if these checks, or if these checks bounce, then also file a check bounce case against him. That's a criminal proceeding, and that will pinch him more. Now, as far as the civil case is concerned, where do you file the case? You file it in a court which has jurisdiction over the scheduled property, or where the property is located. If there's an arbitration clause, then you appoint an arbitrator, and you file your claim before the arbitrator. What is the court fee? The court fee is 1% of the rental value for 1 year. Now, what is the court fee? The court fee is 1% of the annual rental value that is payable directly to the court. So to summarize, if you have tenant problems, please file a suit for eviction along with an application for payment of undisputed arrears of rent. Also, in the main suit, also ask for payment of the balance rental amounts. I hope that video was helpful. Thank you for watching.